guess there's a difference between if you all have your microphone on or off, and then he has to adjust everything accordingly, just so you know.
Okay.
I don't know if that's right.
I'm sorry, I won't push any more buttons.
No, it's fine.
And Your Honor, the court order that I'm referring to was signed by Your Honor on January 24th, 2022. And it was, the court order was in response to the fact that some of our experts objected to turning over their data.
I remember.
Because it's copyrighted information and the answers are confidential, etc. Your Honor required them to turn it over with the understanding that it could be utilized by the state's experts to come to their own conclusion about it, which, obviously I think makes sense that they be able to make their own determination. But then what happened is Ms. Browd was deposed by the state. And during the course of Ms. Browd's deposition that was conducted by Mr. Marcus, a bunch of the questions from the Vineland 3 were asked by Mr. Marcus of Ms. Browd. And so obviously the information that was designed to be used by the state's experts is being used by the state's lawyers for purposes of questioning defense witnesses. And of course the purpose of this is to try to get contradictory answers from Ms. Browd, contradictory to the answers that she gave to Dr. Brown on the same subject matter. The issue is that the Vineland 3 interview is, first of all, it's a copyrighted instrument, and it requires specific qualifications to even be able to buy it and use it, because you have to be a licensed psychologist or a clinician working with a psychologist. There are various qualifications. And also, it is not the type of thing that can just be asked as a list of questions. There's a specific approach to how a Vineland 3 interview is supposed to be conducted. And it, of course, involves establishing rapport with the person, talking about their memories about various periods of time, and their memories of the subject to whom they are referencing. And so what has happened is that the state has used these questions contrary to the manner in which they were designed to be used. And they're designed to be used by a practicing psychologist or clinician, somebody who knows how to conduct this interview, not to be used by a lawyer just reading off the questions and getting contradictory answers. So it's our belief, and I think it stands for itself, that the state is attempting to ask these questions of Ms. Browd to get answers that are contradictory to the answers that she gave Dr. Brown. The problem is that the way that the questions were asked by the state is inconsistent with the manner in which the Vineland 3 is supposed to be conducted, and it's not supposed to be conducted by somebody who isn't a practicing psychologist. So what we expect is that when Ms. Browd's testimony is perpetuated on Thursday, that they will again ask these questions, and then the answers that they get from Ms. Browd, they will be able to use to either impeach Ms. Browd's memory about Nicholas at various points of his life, or to impeach our expert by saying that, well, Dr. Brown says that Ms. Browd says X, Y, and Z, but when we asked Ms. Browd the same thing, she said A, B, C. And that would be an improper use of the instrument. And the reason why we asked Your Honor to keep this exhibit confidential is because it includes the questions that Mr. Marcus asked, and because it's copyrighted information, we didn't want to make it public because that would be directly contrary to the court's order and also to the publisher's requirements, the publisher being Pearson Publishing. And in the motion, DMIL 14, the original motion, there is some language from the American Psychological Association about how these assessments are supposed to be conducted. and very specific language about the qualifications that you need and the extent to which, if you are qualified, you should go to protecting the information that is given to you. There's also information from an affidavit from the author of the Violent Three, who looked at the transcript of Ms. Browd's deposition and has described in the affidavit how the state's use of the questions was inappropriate and contrary to the actual manual for the Violent Three. And she's obviously a doctor who wrote the Violent Three and is involved in creating the manual for its use. So the crux of our motion, Your Honor, is that we are asking the court to prevent the state from asking these questions of Ms. Browd because they are using the questions from the Violent Three assessment instrument improperly, and the questions are being asked of Ms. Browd not by a licensed psychologist or clinician who would be allowed to purchase it and use the instrument, and also that it's contrary to the court's order because, as I read the court's order, the data from our experts was supposed to go to the state's experts for purposes of arriving at their own conclusions, as opposed to being used by the state's lawyers to cross-examine defense witnesses. I believe that's the crux of the motion. Thank you.
Sure.
If I may inquire of defense, is this your argument as to the confidentiality motion? There's two motions here. You have your motion in limine and motion for confidentiality. What were you arguing both, or?
I was, yeah. I started off with the confidentiality. I didn't reference anything in the confidential exhibit but I still wanted to just make the court aware of what my argument was on the main motion. But I didn't want to actually say out loud anything in the exhibit because I feel like that would be publishing the confidential information. Does that make sense?
Well, thank you. I appreciate you answering my question. I know you didn't have to, but I appreciate you doing that. I didn't quite understand what Mr. Secor was doing right there. I'm prepared to make the argument on the motion in limine. The motion for confidentiality, if it's only addressed to what the clerk does with it, I don't have a particular objection to what the clerk does, but I do have an objection as to what can be said in court here today, because and I'll go through it as to why. I don't know what their intent was. It doesn't make clear in the motion. If it's just for how the clerk keeps it online, or when we were speaking in court.
I can clarify that, Judge. Exhibit F, you don't have it. There's in the motion. There's just a sheet that said it will be provided in court, and it was provided in court today with that motion requesting confidentiality of that exhibit. In that exhibit, we have the actual questions that were taken from the Vineland. Those are copyright protected by Pearson. It was in order for us to advise the court as to what the actual Vineland questions were, and then the questions that Mr. Marcus asked in that deposition, we have included that in that exhibit.
I thought you said the deposition was happening this Thursday.
It's a perpetuation of testimony.
So how do you know what questions he's asked already?
Well, it's a motion in limine. Well, because she was deposed.
Got it.
She was deposed. And in the deposition, which is attached as an exhibit, Mr. Marcus asked questions that were exactly from the Vineland 3 or very similar to the Vineland 3. So those are from a standardized measure, right, that is copyrighted by Pearson Publishing. So the protective order that the court signed was in the spirit of Pearson's protective order language, which is we're not supposed to publish it, we're not supposed to speak about it, because it would violate.
I object to two arguments. I thought Ms. McNeil was just going to clarify something, and that would be fine, but they don't get two chances to argue the same motion.
So
basically you're moving to prevent the state from asking certain questions of a witness during the perpetuation of their testimony on Thursday based on your position that the matters are copyrighted by Pearson?
Yes, that's one issue.
Okay,
And then the second issue is what Mr. Secord just argued, that asking the questions in the manner in which Mr. Marcus did in the deposition is inconsistent with the standardized measures, standardized method and procedures that the test should be administered. And that's why we included the affidavit from the actual author of the Vineland 3, saying that they should, the way in which the questions were asked were, one, unqualified person, and two, doesn't accurately measure the purpose of the Vineland 3. So that's the main issue. So we just want to prevent the state from asking those questions in the perpetuation of the testimony. Maybe they don't intend to do that, but because of their deposition, we wanted to bring to the court's attention because this witness is very sick. And we don't want to delay the perpetuation of her testimony.
okay.
Judge, let me apologize in advance. This is going to be a bit of a lengthy argument.
Okay.
So, Your Honor, the defense motion in limine seeks to eliminate portions of the cross-examination of Finney Broward. Now, the defense argues in their motion that in the deposition, the state, and this is at page 6 of their motion, quote, administered the Vineland test to Ms. Broward. They stated that...
you're not on the motion to determine confidentiality, now
No.
you're on the motion to eliminate.
Yes.
Okay, page 6 you said.
Page 6, and it was... You'll see that in paragraph 11. That it was me, Your Honor, who took the deposition. So if it's not clear, I guess it is clear in here that it was me. That I am not qualified to administer the Vineland 3 because I'm not a licensed psychologist, and that the manner in which these questions were asked was inconsistent with the appropriate administration of the Vineland 3. The defense goes on to say that they are fearful that the questions and answers would be inappropriately relied upon by state experts in forming their opinions. They say because the deposition transcripts are public, I have compromised the entire integrity and security of the Vineland 3. Now, just for the record, I never mentioned in the deposition the Vineland 3. There was a point in the deposition, as I recall, and I'm sure Ms. Curtis remembers this, and if she remembers it differently, that would be fine if she remembers it and she wants to correct me. That as I was asking some of the questions, and I believe at the time the defense did not have the raw data. I think their position was that they don't want the raw data. And then I was asking questions that she didn't understand the relevance, and we went off the record, and in fact we had a phone call, so it wasn't something that anyone could hear on a Zoom call. And it was at that point that I made Ms. Curtis aware that if she had gotten the raw data, she would understand the questions that were being asked of the witness. So for the record, again, the state never mentioned the Vineland, and if the defense was so concerned about the publishing rights of a company that has virtually nothing to do with this case. This is a death penalty case. This is a penalty phase. I don't think it's genuine that they're concerned with the publishing rights of a company that is forced to give up these raw data because there's a court order that says it has to be. Of course, it wasn't them directly, but the experts themselves. It's a court order that causes this data to get to the state and to the experts. I do want to clarify something that Mr. Secor said in his remarks earlier. He said that it was turned over to the state's experts, and it wasn't turned over to the state's experts. It was turned over to the state attorney's office, and the order makes it clear it was turned over to the state's experts, to the state attorney's office, and the state then turned it over to the experts. There was no indication that the state attorney's office was not going to get possession of the raw data. It is a matter, psychologists don't have special dispensation from the courts. If it was an MRI, we would get an MRI and we could question a doctor about an MRI. There's no confidentiality about an MRI. It's no longer confidential when it's been turned over to the opposing party and its experts. We can ask any questions that are deemed appropriate, and of course, because we're not psychologists and we may not be radiologists, of course we consult with our experts. Now, the defense attached an affidavit as defense has stated by a Dr. Saulnier. Is that how you pronounce his name? Saulnier? And they...
Which exhibit? I mean, which motion?
I'm only addressing the motion in limine 14.
I don't have
Her
an
exhibit.
attachment, I don't think, on my
I
copy.
believe it's a 3-page document.
I have a 7-page motion in limine DMIL 14, but I don't have an attachment to that. Is that something I can get off the?
You should be able to, Judge, but I have a copy of the affidavit. I'm just trying to find out the number of the exhibits.
I don't have any attachments to that particular document, so
Okay.
if there are multiple exhibits, I can go on the CMS and print them.
It's Exhibit G. It's a 3-page
May I
document.
approach, Your Honor?
Sure.
It's like 268 pages
Maybe that's
of
why.
exhibits. Some of them are depositions. But this is.
Is this for me to keep or do I need to?
No,
give
you
it back?
can keep that one. That's copy.
Let me just pull up the document on the.
That's Exhibit G, Your Honor. Affidavits from the Vineland 3 office.
It's not. All right. So if you're referring to an exhibit, just let me know, and I'm gonna have to get a copy because I don't think the attachments are in the computer either. Is it? All right. Second.
It's a second exhibit. One is the motion, one is the exhibit.
All right, let me just pull up the document. Okay. I see. Thank you.
So if Your Honor has the motion, paragraph 16 is the quote I was going to read anyway.
Okay, go ahead.
There's a quote from I would like to quote Dr. Saulnier as well as the defense did. They did in paragraph 16 on page 8 of the motion in limine, where she said that the deposition of Ms. Broward is not a reliable or valid assessment of Mr. Cruz's adaptive functioning because the questions asked were not asked in a manner consistent with the Vineland 3's manual instructions for standardized administration of the instrument, nor were the questions asked by a qualified examiner. Therefore, no quantifiable or interpretable data can be generated from her answers. And said the deposition of Ms. Broward, in my opinion, is not a suitable substitute for and does not validate the Vineland results collected by Dr. Brown. First of all, in terms of this affidavit, the state is going to move to strike the affidavit. And affidavits are not admissible to prove facts in issue at a hearing because they are not subject to cross-examination and because they impermissibly shift the burden of proof to the other party. And I would cite to the court two cases, Fortune versus State, 611, Southern 3rd, 441, a second DCA opinion from 2011. I have a copy for the court.
Thank you.
And a second case, it's for the same purpose, that an affidavit is not admissible to prove facts in issue at an evidentiary hearing. It's not, because it's not subject to cross-examination and would improperly shift the burden of proof to the adverse party. And that is Doug Sears, S-E-A-R-S, Consulting, Inc. versus ATS Services, Inc. at 752 Southern 2nd, 668. It is a first DCA opinion, 2000.
Thank you.
Dr. Solinger is not here to be cross-examined as to what information she had, what she was given. It is completely useless to the court what Ms. Solinger says in an affidavit because it's not subject to cross-examination. And we will move to strike that affidavit. Your Honor, it would be appropriate at this point to go what to the law is concerning raw data and testing information. And as the court appropriately granted the state's motion for the raw data, the court at that time relied on the Florida Supreme Court decision of Abdul, A-B-D-O-O-L versus State, 53 Southern 3rd, 208, Florida Supreme Court case in 2010, as well as Bailey versus State, 100 Southern 3rd, 213. It is a 2012 decision from the 3rd District Court of Appeal. The 3rd District said a defendant must disclose raw data from mental health experts prior to a penalty phase proceeding. The defendant in Abdul complained that the trial court erred when it ordered the defense to produce raw data from the defense's mental health expert prior to the penalty phase. The Florida Supreme Court disagreed with the defendant. The court reaffirmed that Rule 3.220 applies to the penalty phase proceeding and noted that the mandated reciprocal discovery includes disclosure of reports or statements of experts. The defense battled this issue, very much so. They did not want to turn over the raw data. Then they tried to get a compromise as to what it could be used for. The court's order, the court granted the order, and then I believe the defense asked for a rehearing, and they wanted to try and put limits on the disclosure. And the court ended up having it turned over directly to the state. The court order states from January 24th, 2022, that the court finds that the defense expert shall provide all materials used and made in connection with this case, including raw data, directly to the Office of the State Attorney. The Office of the State Attorney then may only share such material with any experts or consultants in the field who are consulted in this case. The sharing of such materials shall be done securely, and any experts or consultants who gain access to this material from the state shall not disclose the material to any other individual. Such raw data materials shall not be copied by any party or individual, and such materials shall not be made publicly available or become a part of the record in this case. The court notes that providing the Office of the State Attorney directly with the materials in this matter is for the purpose of streamlining the process and to ensure efficient and seamless consultation with its experts. Furthermore, although this court does not believe this would be done, the attorneys are not to use the raw data to attempt to form their own interpretations or analyses of the materials. All interpretation and analysis of the data shall only be made in consultation with its experts. I'll state for the record that the state did consult with its experts before the deposition. Your Honor, the defense in their entire 11-page motion, this motion in limine, cited one case, and that case was a 1949 decision from the Florida Supreme Court called Pepper. Let me see if I got the pronunciation. I think it's P-E-P-E-R versus Edell, E-D-E-L-L. And I'm sorry, it's Perper, P-E-R-P-E-R. 44 Southern 2nd, 78, Florida, 1949. This case has nothing special to do with this particular case. There's nothing particularly on point about it. It's essentially a 403 analysis that if the evidence tends to confuse or obscure rather than illuminate the true issue before the jury, then the evidence should be excluded. The state would argue and will further argue, and it'll be clear as I get further in my argument, that the state's cross-examination actually doesn't, it actually illuminates the true issues before the jury instead of obscuring or confusing. This opinion, so the defense has no case law to support their argument that they are making today. The defense adds in an exhibit B, which is the APA, I guess that's the American Psychological Association guidelines for psychological assessment and evaluation. And they quote extensively to the APA guidelines. What they don't quote is what are the APA guidelines? What exactly, who does that cover? They have somehow placed me as the prosecutor as someone who did not administer the tests correctly, like I'm a psychologist. I'm not, I'm a lawyer. I'm a lawyer doing a deposition. Now they have placed the American Psychological Association guidelines for psychological agreement on me as the prosecutor in this case, when it doesn't apply to me. I'm a lawyer, not a psychologist. And in fact, on page 4 of their own exhibit, it makes clear that this is for psychologists. And then it makes a statement distinguishing between guidelines and standards. And it says, the term guidelines refers to statements that suggest or recommend specific professional behavior, endeavor, or conduct for psychologists. Guidelines differ from standards. Standards are mandatory and thus may be accompanied by an enforcement mechanism. By contrast, guidelines are aspirational intent. They are not mandatory, definitive, or exhaustive. They aim to facilitate the continued systematic development of the professional and to promote a high level of professional practice by psychologists. It goes on to state that as a result, guidelines are not intended to take precedence over the professional judgment of psychologists that are based on the scientific and professional knowledge of the field and the ethic codes, and this is the most important line here, further, federal and state laws also supersede guidelines. So these psychological APA guidelines is completely meaningless because state law controls that the raw data can be shared with both parties. Equally, Exhibit C is ethical guidelines, APA ethical principles and code of conduct. And I'm not sure why they have sent this as well, because it applies to psychologists. It doesn't apply to lawyers who get a court order to obtain the documents. And in fact, on page 2 of 4 of their exhibit, under 9.04 release of test data B, in the absence of a client-patient release, psychologists provide test data only as required by law or court order. So Exhibit C, like Exhibit B, is completely and utterly meaningless to this hearing. That is the authority that the defense is trying to use. They're trying to use the ethical guidelines and the code of conduct of psychologists. Completely meaningless. Now, the defense did not include, there are other guidelines, but more specific for forensic psychology. And I have a copy of that, and that's not the law here either. Those are guidelines for forensic psychologists, and that's what we're involved with is forensic psychology. And I do have a copy for the court and defense. I would like to offer it as a state's exhibit. May I have it marked for this hearing, please? And moved into evidence as an exhibit? I'll give it to the court for now. Your Honor, I'm not suggesting that this is law that governs this case either. It only stands for the proposition under paragraph 11, that's on page 16. Forensic psychologists know that when they go into that business, they will have to turn over data if there is a court order that tells them to do that. They do have ethical responsibilities of when to try and resist if possible, but once there's a court order, that's it. They have to turn over the data. That's their responsibility. And in the middle of, it's actually guideline 11.01, accuracy, fairness, and avoidance of deception. When responding to discovery requests and providing sworn testimony, forensic practitioners strive to have readily available for inspection all data which they considered, regardless of whether the data supports their opinion, subject to and consistent with court order, relevant rules of evidence, test security issues, and professional standards. So, Your Honor, the defense psychologists they can make their objection, which under their ethical requirements they may be required to, and they did that through defense counsel. But that's as far as it goes. Once the court orders its release, it does get released, and that's what happened in this case. It was released. Now, Your Honor, the defense has now filed State's Exhibit F, which is purported to be what questions that I asked at deposition and which they found a similar subject matter in the Vineland 3. The Vineland 3 measures adaptive behavior. So there are areas where you would normally ask a witness in deposition who is familiar with that person during a certain time period about their adaptive behaviors. It could be combing their hair or going to the bathroom, things related to the timing of when they may have accomplished those tasks or brushed their teeth or things like that. And some of those things are questions that I ask, and I will go through that. What's important to the state is some of the answers that were given. In the Vineland 3 by Finney Browd, purportedly to Dr. Brown. When I say purportedly, Dr. Brown contends these were answers that she was given. Finney Browd had no memory of even being asked the subject matter of some of these questions. The Vineland 3 and the results were given to some of our experts, including a Dr. Gilmet. And Dr. Gilmet's deposition was kind enough of the defense to include that as an exhibit in their motion in limine, and that is Exhibit H, deposition transcript by Dr. Gilmet. Now, on page 62 of Dr. Gilmet's deposition, he's a forensic psychologist. On page 62 of his deposition, he is addressing at this particular question the results from the Vineland 3 from Finney Browd. And on page 62, lines 11 through 16,
Okay, 62. One second. Lines 11
yeah,
through 13.
yes.
I'm on the page.
Okay, so his response, the question was asked, or his answer was that Finney Browd's responses from the Vineland 3 would have indicated that Mr. Cruz, or did indicate, as it was scored by Dr. Brown, that Mr. Cruz had a receptive language ability of 1 year and 8 months. So this was supposedly when he was 11 years and 9 months old, that based on answers that Dr. Brown said that Ms. Browd gave on the Vineland 3, that he had a receptive language ability of 1 year, 8 months. And as an example, one of the questions that was asked on the test, as well as a question that I addressed in deposition, was at the age of near 12, 11 years, 9 months, how many words did he know? Did he know? And according to the Vineland, he did not know even 50 words. And that would be a reason why his receptive language ability would be 1 year, 8 months. If at nearly 12 years of age, he didn't know 50 words. That is completely absurd.
Judge, I'm going to object to the relevancy of these questions. The issue before the court is whether or not the state of Florida can ask Vineland-type questions during the perpetuation of Finney Browd's deposition. It's not to get up here and try and get into evidence what other experts are saying. So we would ask that Mr. Marcus tailor his position and his argument to the intent and the spirit of this motion before the court.
this is the reason why it's asked. We always have an opportunity to question a test. A psychologist doesn't get to give a test and doesn't get to be questioned as to why this result is appropriate. They can't cite one case that says we can't. That's why we're able to get the raw data so we can question it. We're not getting the raw data so we can ignore it. It's to look into, is this raw data accurate? They have a problem with this because there's tons of school records. Everyone knows what his progress was in school. He was not at 1 year and 8 months when he was nearly 12 years old.
All right, your objection's overruled.
Indeed, in question that came out in the deposition was that, or a subject that came out in deposition not having to do with the Vineland, had to do with when Mr. Cruz's father died. He was nearly 6 years of age. Ms. Browd stated that when she saw the defendant right after the death, he asked her, is my father going to heaven or hell? And he was not yet 6 years of age. So clearly someone who could not even form 50 words at 12 years old, at less than 6, wasn't going to be able to understand concepts of heaven and hell and articulate such a sentence. And Ms. Browd articulated many more words than that he was aware of. So it's clear that the Vineland answer, which was that he did not understand 50 words at 12 years of age, is an incorrect answer, in that Ms. Browd was able to articulate many more words that he could speak, and then looking at other data, and then this is from the psychologist, looking at all the other data, it would have been notated in the school records that he was that far behind. So the Vineland on its face was incorrect, at least as to that question, and several others that the state got into the deposition. Dr. Guillemette further testified at the deposition that, and I'm looking at now page 69, starting at page 68, line 24, defense asked, when I asked you about the deposition that I think is the second one, April 7th, 2000, it says 2002, it should be 2022, you said that the answers in the deposition were inconsistent with the answers on the Vineland. Did I understand that? Or were different, or that's what you took away from the deposition? Yes, that's the answers reflected a higher level of functioning. This is an expert witness for the state, having read the deposition that the defense complains about, can see from the deposition that his functioning is not as was described or reported by Dr. Brown's analysis of the Vineland. It was further his opinion on page 71 of the deposition that the Vineland results do not reflect his functioning, his functional adaptive behavior. The questions that were asked by the state did not reference the Vineland specifically. I was asking questions that are just typical of what adaptive behavior, what accomplishments, what the defendant's capabilities were. On page 34 of that deposition, which I believe is April 7th, he was...
Mr. Mark, Ms. Brown step up?
Yes, is it April 7th?
She had two, so,
The first one was in December.
so there is April 7th, yes.
Thank you. The questions asked, at ages 4, 5, and 6, were you around the defendant when he was eating? Getting information about how he ate, that's an adaptive behavior. The specific age that Ms. Browd was supposed to report on, according to the Vineland, was at 11 years and 9 months. I was asking at different ages, because if you could accomplish at a younger age, then then presumably he was retain that skill when he's older. She reported that he would say, I don't want this, I'm not eating this. Again, this is ages at 4, 5, and 6. These are words that he's saying as well. She could understand him at those early ages, 4, 5, 6. She would explain to him that he needed to eat what his mom made, and the defendant would understand. She indicated that at the ages of 4, 5, and 6, he was able to watch cartoons like a normal kid. At the age of 7, he would watch the History Channel about animals at 7 years. These are all behaviors that Dr. Brown states in the Vineland that he did not have the abilities to watch a show like that even at 12. That he was a help in the kitchen as a young boy, that he was able to set the table, including plates, napkins, forks, and knives. At age of 6 and 7, he was using a microwave. He helped feed the dog. He was doing chores at 6. He understood what the word no meant, which was indicated by Dr. Brown that he didn't understand the word no. There was questions about gestures. What gestures could he do? And Ms. Brown didn't say at 12 he couldn't do it, as was indicated in her responses. She said that at 4 to 6 he understood what these gestures were such as like a finger, as I'm indicating, Your Honor. I'm using my pointer finger as a gesture like come to me. He understood a sleep gesture, putting hands on one side like a sleep gesture. He understood if you put your arms out, that was a welcoming gesture, and he would come in and allowed to be hugged by Ms. Browd. These were gestures that he understood that Dr. Brown said didn't happen, did not give him credit for these things. That he clearly knew 50 words at 6 years, let alone 12 years of age. There was also the concept of knowing things such as behind or in front of or between, like a toy being in front of a couch or behind a couch or between cushions. She said he knew all of those concepts. She also testified that there are some things that she doesn't recall because it's too long ago. And quite frankly, that is one of the criticisms of it's called a retrospective test, in that you're asking somebody to 10 years later, if they were a caretaker or had a lot of exposure to the person, to be able to say, what do they do when they sneeze? People may not remember how they handled a sneeze. In fact, our doctor says, I can't tell you what my 6-year-old did at 6, or my child who's not 6 years is way beyond that now. I can't tell you what he did at 6 years. Can't tell you if it was 6 or 8 or 10. I know that they did this, this, and this, but I can't tell you at what age. This test is asking, okay, at this age, at 12, did he do this? Did he do this? Did he do that? And several of those questions were asked, and she said, I remember events. I can't tell you what date they were. So this all goes to the credibility of the examination that was given by Dr. Brown. He indicated, or she indicated, and Ms. Browd indicated that the defendant brushed his teeth when he was 6 to 7 years of age, which was indicated at 12 that he didn't.
whether or not he could zip up a jacket or button a shirt, that he could play a game like Tetris on the phone at 6 years of age. These are all relevant questions as to his adaptive behavior. Whether it was related to this particular test or not, these are appropriate questions to ask because adaptive behavior is an important component in determining whether or not he qualifies under the diagnosis that the defense is contending that he has. And this, so those were the issues that went in, that were asked of Benet Broward. So, Your Honor, it is entirely appropriate. The state receives the data, went over it with its experts, and formed questions in a deposition that were important to determine if this test itself, the Vineland, is accurate. Because you're asking people to remember something that happened. In this case, it was about 10 years earlier as to what he did, his adaptive functioning in each of those areas. What she could remember was inconsistent with what Dr. Brown reported. And this is a valid cross-examination, and it produced data for experts to look at. As Dr. Guillemette looked at this data that was created in my deposition of Ms. Broward, and can say, this Vineland test is not something that can be relied upon. If you look at, not only look at the deposition, but you look at all the data that they have from his school records, you could see that he was not at 1 year and 8 months at 12 years of age. That would have been documented in records, which indicates that either Ms. Broward was a very poor reporter or Dr. Brown did an incompetent examination. Either way, it indicates that the Vineland test should not be a reliable piece of data for any of the experts to use because of all these problems. For all these reasons, these are valid matters that can be raised in cross-examination. How are we to confront this test unless we ask about data that doesn't make any sense to any of the experts? We're not in a position, or no party would be in a position, to merely accept what the psychologist is saying. We did not administer the test. I was a prosecutor asking questions in a deposition. Whether or not an expert can rely on that information, this all goes, it goes to weight. It doesn't go to admissibility. The jury should hear what the competing stories are, and they will have to make a decision as to whether or not the Vineland is a reliable test or not. The state's position is that it is not reliable, especially how it was done in this case, especially with Benet Broward's subsequent answers, where she doesn't support any of the answers that Dr. Brown says. I won't say any. Several answers she does not support. Some she does support. But those are important distinctions as to what level he would be at. So for all those reasons, I ask you to deny this motion.
May I respond, Your Honor?
Yes?
So, at the beginning of Mr. Marcus's presentation, he said that during the deposition there was an off-the-record conversation about questions he was going to ask relating to the Vineland. That was actually in reference to the personal behavioral checklist and the brief symptom inventory. I made those objections because I thought that the brief symptom inventory, also known as the BSI, was copyrighted. We stopped. I contacted Dr. Brown because I wanted to make sure that we weren't violating or participating in the violation of a court order or violating any copyright laws. And she said that the brief symptom inventory, also known as the BSI, is widely used and can be used by non-professionals as well as professionals, so there was no copyright issues. So I just wanted to clarify that. It had nothing to do with the Vineland. The defense is still not in
I object to
possession.
that. I think my conversation was with Ms. Curtis, not with you, as as I recall.
I have a different recollection.
Yeah, you had that conversation with me.
You were on the depot, right?
No, but we're talking about a different I'm sorry.
It's okay.
We're talking about a different deposition.
Well, then you can make that in your argument.
I'm not making any argument, trying to help you.
Thank you, sir.
You're welcome.
I never would have agreed to allow no member of the defense team would have allowed questions taken from the violin to be used in a deposition. It wasn't until after the deposition of Mrs. Browd was taken and was sent to a defense expert that we were advised that portions or questions from the violin were administered to Mrs. Browd. We still do not have the raw data because we do not believe that we should have it. And just in terms procedurally, Judge, the defense initially agreed to turn over all of the raw data, and the court signed some initial orders. And then on May 21st, May 21st, 2022, after our experts contacted us and said we cannot comply with this court order without protected language. And their concerns were that releasing test data to individuals who are not trained in the administration and interpretation of the data is a direct violation of the American Psychological Association's ethical guidelines for psychologists and neuropsychologists. Their second objection was releasing raw data and test instruments to unqualified professionals, Mr. Marcus, or myself for that matter, increases the risk and likely possibility that the data and the findings will be inaccurately interpreted. The analysis will be limited to admitting standardized findings and quantify the results because individuals that do not have the training and the skill to recognize and identify what is actually being presented in the data. And the third argument, or the third objection that our experts had was the experts are unwilling to jeopardize the security and the integrity of the test instruments by consenting to the release of copyrighted and confidential materials to those not professionally qualified to obtain them. We had a full hearing. I'll rely on those pleadings because we added ethical considerations for both forensic psychologists as well as neuropsychologists. And the court did sign an order, and that order was January 24th, and Mr. Marcus read part of the order into the record. But what the court also said in that order was, furthermore, although this court does not believe that this would be done, the attorneys are not to use the raw data to attempt to form their own interpretations or analysis of the material. All interpretations and analysis of the data shall be made only in consultation with the experts. So this is the objection that the defense has. The Vineland 3 is a standardized, normed instrument. And one of the reasons why when you are assessing individuals' adaptive functioning, that this instrument is used is so that it is always administered the exact same way. That's what makes it reliable. You're not supposed to use open-ended questions, as the author of the manual says. You're supposed to use either a comprehensive interview form, if you're a parent caregiver, or a comprehensive interview form if you're a teacher. The questions are graduated. So, and I used this one in the deposition. The question is, does your child brush his teeth? Yes, my child brushes his teeth. Well, how many times do you have to ask your child to brush his teeth before he brushes his teeth? Oh, 10 times. So after you ask him 10 times, does he brush his teeth? Well, I actually have to walk my child into the bathroom. And then does he brush his teeth? No, I have to get the toothbrush out and I have to put the toothpaste on the toothbrush. So if the question is, does your child brush his teeth? And you say yes, without any probing, which is exactly what the Vineland is supposed to do, and finding out all those other steps, you have an accurate measurement of adaptive functioning. So that's the reason why unqualified and untrained individuals are not supposed to cherry pick questions from a standardized measure and ask individual questions about adaptive functioning. In fact, give me 1 second, I'll pull this transcript out. In Dr. Galmetti's deposition, who, for the record, has never administered the Vineland 3 and only bought the manual for the purposes of this case. I asked him on page 79, line 8, I only have a couple more questions. Just let me look at my notes. Is it appropriate to rely on Vineland questions that are administered by a non-professional? Mr. Marcus objects, asked and answered. Witness says, I don't think he answered it. That's what the witness said. And then I say, you can go ahead. Answer, you mean to take a Vineland question in the Vineland format? Right. Answer, I don't, a lot of questions does it make I question. Well, tell me what makes the Vineland assessment reliable. Answer, well, the assessment means that it is administered in the way that it has been standardized, that it was standardized. Question, okay, so if a non-professional asks Vineland questions, is it appropriate to rely on those responses? Response, so long as they're not saying that this contributes to a Vineland score in any way. It's a question that's out there versus asking a question from the Vineland and then using it in a way to indicate that this Vineland scores or that this contributes to a score in a Vineland. And then I ask, well, so there's a lot of questions that you can ask about a person's functioning that would be equivocal to the questions that are on the Vineland. That was his answer, I'm sorry, question. But the Vineland questions are done systematically and methodically, correct? Their expert said yes. Question, and the answer should be more than, and the question should do more than govern a yes or no response, correct? In order to do a proper assessment of adaptive functioning. So, Mr. Marcus, and it appears to me that he's conceding that he used questions from the Vineland. I only know that because my expert reviewed the Vineland and then the deposition. Took questions out of an instrument, and there's 3 domains on the Vineland 3. He didn't ask all the questions in the Vineland. So even if he was a qualified professional to administer the Vineland, he didn't administer it the way that it should be administered. So that makes any information that he gathers unreliable because he's taking information from a test and he's using it inappropriately. Not in a standardized measure, which guarantees the reliability. If Mr. Marcus believes that the evaluation of or the Vineland that was administered to Finney Brown is not a reliable piece of data, he can have his experts provide testimony in their case or in rebuttal. Mr. Marcus is not a qualified individual to make those assessments. Our objection initially was that the state, and Mr. Marcus is correct. The court did say that the documentation could go to the state's experts. So I'll correct that statement and I'm in agreement with that.
The state.
To the state, and then they could administer it to the state's expert. But our concern, which is consistent with the concerns from the American Psychological Association, the ethical principles of psychologists and code of conduct, and the other document that Mr. Marcus relied on, was that attorneys should not attempt to form their own interpretation or analysis of the material. This is exactly what Mr. Marcus did. He took questions, used them in a yes or no, eliciting a yes or no response, and that's what Mrs. Brown responded to. It was not asked in the manner in which it should have been administered correctly by the Vineland. I have one. And releasing this information consistent with the court order doesn't make it a free-for-all for everybody who has possession of it to use it. There still are limitations, which the court clearly recognized. That's why you fashioned the order that you did, so it would be consistent with the publisher's concerns. Just a moment, please. Using a map. And when Mr. Marcus asked questions directly from the Vineland, he not only violated the copyright laws, which is not an issue that we need to take consideration with. That's up to Pearson. But what he did was he improperly administered questions from the Vineland. The responses to those questions are not reliable because they're not standardized. Consulting with their experts about the raw data is 100% permissible. We've done it, although we don't believe we have the right to possess the data. The state has actually taken a step further and done something that is 100% impermissible, not only in contrary to the publisher's recommendations or their guidelines as to what they're asking the court to do when they believe that they have to return the raw data over, which is to add the protective order, which is what the court did. So Mr. Marcus has taken this data, he has formed an interpretation in his brain, and then in order to support what he believes that information means, he asks the deponent a question. And it's not the way that this test was supposed to be administered. As far as the affidavit, Judge, Mrs. Curtis can make arguments about whether or not you are in a position to be able to strike that. But our request is that you prohibit Mr. Marcus from asking Vineland-like questions. And Judge, we're going to bring a hard copy of all the exhibits for you so that you can see, and their own expert says that an unqualified individual should not be administering the Vineland, and that the Vineland questions should be done in a systematic and methodical way. And that would include all three domains. That's not what Mr. Marcus did. This is why the defense back in January of 2022 objected so strenuously about this material being turned over to the state. And they did exactly what we were concerned with. Very simply, Judge, this is a 403 argument. He doesn't know the material. He's not authorized to administer the material. He's not authorized to interpret the material. And any probative value of the answers to his questions is outweighed by the potential to mislead or confuse the jury. And I defer now to Ms. Curtis about the case law on the affidavit. And I believe she also has some arguments that we already made about Abdul when we first argued this back in January.
Judge, first of all, objective. You already got two people arguing this already. I don't think a third is necessary, but I do want to respond. First of all, to Ms. McNeil. I'm sorry to point out, it's right in the transcript of the deposition of Ms. Benet Browd that I was talking to Ms. Curtis. Ms. Curtis made an objection. Ms. Curtis objected. You're asking her questions now. And I said to Ms. Curtis, I'll talk to you on the phone if you like. If you want me to do that, we'll go off a moment. And Ms. Curtis says, sure. And then we came back on. There was no other objections from the defense. So this entire argument by Ms. McNeil is completely inaccurate. And in fact, Ms. McNeil is not even showing as on the appearances. So she wasn't even there for the deposition. She does not know what she speaks about what happened at the deposition. Next, the state, meaning me, did not administer a test. I asked questions that were relevant to his adaptive behavior. Those are questions that are in the Exhibit F. Questions like, did he know how to use a microwave? Did he know how to use a toaster? Those are not copyrighted questions. There is no particular, first of all, they don't represent Pearson. This is a penalty phase hearing where the raw data is appropriately with the state. They could have had it. They chose not to. And we turned it over to our experts. These are appropriate questions to understand what his adaptive behavior is, what his adaptive behavior was. Did he ever watch a documentary on animals or something like that? And they said they're liking it to a question that is on the Vineland, but it's not asking the exact questions. It's the subject matter. It's all of his adaptive behaviors that he has. Those are completely appropriate behaviors. Understanding gestures is an appropriate behavior. That's why probably Vineland put it a similar question or a similar idea. These are not
particularly unique ideas for adaptive behavior, and how many words he spoke. What we were able to uncover from the deposition is that Ms. Browd said, I was never even asked a lot of these questions. I was never asked this question by Dr. Brown, which really goes more to not impeaching Ms. Browd, but more impeaching Dr. Brown for her examination and claiming that these were questions that were asked and answered or in her interview. It is appropriate for us to go into it. How would we know if she did an appropriate examination? Who was there to tell us? It's Dr. Brown and Ms. Browd. We have to ask one or the other or both what happened. Dr. Brown contends this is what was asked. Of course, we asked the other person, is there what happened? What were the questions that were asked of you? And she answered those. Those are appropriate matters for cross-examination. The state is entitled to do a cross-examination of the witness. We get to test the witness's knowledge of what they know, and gaining information from Ms. Browd is also cross-examination of Dr. Brown as well. This is not a free-for-all in giving and talking about this material. I never even mentioned Vineland. It was the defense who mentioned it in their pleading that this was related to Vineland. They're the ones who, if anybody violated the copyright, all there is a deposition where I'm asking about toasters and microwaves. There's no indication in my deposition that it has anything to do with Vineland. I even went off the record when I talked to Ms. Curtis. It's whoever filed this motion on behalf of the defense told the world that it's Vineland. They're the ones who violated supposedly this agreement or the copyright agreement, but that has nothing to do with us. We're lawyers on a case. We appropriately had these materials, and only the psychologists, the experts also had these materials. It's their interpretation of the answers that's important. It's not my administering what I'm thinking in my mind. I'm not testifying in this case. I'm giving information to experts, and their experts are reading it too, and it gives them information. For example, you take a deposition of the defendant's brother. Any information that comes out of that deposition is considered data to a psychologist. It is data about how he grew up, how the defendant grew up, information about what happened in that home. That's whatever the question is, there's answers. The experts look at that information and then make determinations. Does it indicate this or that? Is it consistent with our experts' diagnosis, for example, of antisocial personality disorder or not? Or is it consistent with what the defense theory is? Anything that comes out in a deposition, it's not for me to testify. It's for our doctors to look at that information and their doctors to look at that information and see if it's data that's important to their diagnosis. And that's all this is. I did not administer a test. I asked questions that were relevant to the test that was given them. All the psychological guidelines and ethics, that has nothing at all to do with this. It is all trumped by this court's order. And that is what controls. It is relevant information. Anything that comes from it, we can ask about. It's valid cross-examination. Thank you.
Judge, I just have a couple things and then I'll finish up. I just want to make a distinction between experts reviewing a deposition of Zachary Cruz or any lay witness and collecting data from that deposition. This is psychological testing that these experts are relying on in order to form their opinion. And these were questions that were taken from a psychological instrument that was standardized and normed, which equates the reliability of that instrument. The doctors cannot rely on Mr. Marcus's Vineland questions to make their evaluation. And our next motion will be how to limit their testimony. But Dr. Gilmetti does in fact do that in his deposition. So this is not normal data. This is data based on psychological testing, which is why the examiner or the forensic psychologist, the forensic neuropsychologist, and the publishers are so careful with who has access to this data and how it is accessed by individuals. And I'm going to request that that the court hear arguments about the case law from Ms. Curtis, because we were just handed this, and as I was preparing my argument to Mr. Marcus's argument, I wasn't able to read the case law, so I would ask that
It's
the
fine
court...
for today, but in the future, folks, each motion is gonna be handled by one lawyer. I know that there are 4 or 5 on each side, but,
Your Honor, this is their motion. We have to be prepared to argue motions. This is their motion, which they submitted one case on sort of a 403 issue from 1949, and they're complaining that they were handed case law. This was only filed at 5:30 last night.
Judge, the defense isn't complaining. We're just asking for an opportunity to review the case law that was provided, and if we have any distinctions that we need to make, that we're able to do that for the court. I also have a hard copy of all of the exhibits if the court wants it.
I accessed the AR and policy, and I was able to follow along on the computer as you all were making your arguments, so it's not necessary. Okay, Ms. Curtis, you want to say something else?
Judge, just with respect to the cases, I mean, I haven't had a lot of time to look them over. However, these are both dealing with using affidavits as evidence in an evidentiary hearing to satisfy the party's burden of proof. This is not an evidentiary hearing. That affidavit was provided to give the court some guidance in an area in which the court may not be familiar regarding what we're talking about and why it's a problem. Similar to the affidavit we attached when we initially argued that the state shouldn't receive the raw data. There are hearings, it's not unheard of, that affidavits can be used in motions for summary judgment, for example. Affidavits or declarations used to support or oppose a motion can be made or must be made on personal knowledge, set out facts that would be admissible in evidence, and show that the affiant or declarant is competent to testify. So were we to call this doctor?
I think we're getting a bit off track here. I'm not concerned about the affidavit.
Okay.
So, however, I do find that the questions at issue that were asked by the state at deposition were fact-based questions that the state is entitled to ask for a number of reasons, whether it be to uncover relevant information or more specifically to undermine the validity of a specific test. This is the very nature of our adversarial system of justice, and the defense arguments, I understand them, but I think they go to weight, not to admissibility. So as far as the motion in limine to prohibit the state from asking these questions at the perpetuation of testimony on Thursday, that motion is denied. As far as making the record confidential,
Just Exhibit F, Judge.
but the record doesn't say, you all are the ones that added what the Vineland actual question was. The record is actually what Mr. Marcus asked.
Correct, but some of the questions are the same or are very similar of the Vineland questions, so we need those to be part of the appellate record, please.
I just object in so much as it interferes with our ability to cross-examine witnesses.
I don't understand that, Judge. I don't know how it would interfere. We just want to make sure that the actual Vineland questions that are in that exhibit are deemed confidential so that they won't violate any copyright laws.
I don't have an objection for that one record.
Okay.
If that's all they're asking for, that's fine.
Okay.
But, Your Honor, for purposes of the perpetuation of the testimony that on Thursday, Mr. Marcus should not be precluded at that deposition from asking any questions that relate as to any arguments made by the defense here today. If they're going to argue that the questions are similar, let's be clear that this court has ruled that those questions are permissible.
I am being clear, as clear as I
I
can be, that
understand
I
the
think
court's
the
wrong.
questions at issue that were fact-based questions and that the state is entitled to ask them.
Thank you, Your Honor.
Perpetuation of testimony and or deposition. All right, we're going to take a 10-minute recess. It is 3 o'clock. We'll take a recess until, we still have other motions, correct?
I'm sorry, Judge, for the motion to determine confidentiality of Exhibit F, you're granting that then?
Yes.
I don't believe the state has.
Granted by agreement, if you want, we can write up a short order, but
Okay.
I need to take a 10-minute recess. motion. Who's going to be my point person from the defense? My point person.
Me.
All right, Mrs. Curtis is the point person. Whenever you're ready, you can let me know what I am considering next.
This is just D300, it's the defense's proposed modifications to jury instruction 7.10, preliminary instructions and penalty proceedings, capital case.
All right, give me just a second to pull up that reading, please. Okay, proposed modifications to jury instructions, D300.
Yes, ma'am. Judge, so what I did was, I took the standard instruction, I don't know if yours is in color.
It's not, but I can see where you have made something a different color because it's printed in gray instead of black. It looks like it.
Okay, so there are certain things.
It's not your fault. We don't.
No.
I told you we don't have color printers.
Okay, so, I mean, I don't know if you can distinguish, but, so what I did was I did a strike through and red of language we were requesting be removed, and in green is language that we asked to be added. There are only 2 green parts, and anything that's in red is struck through anyway. So
Then I'm gonna have a problem because anything that's not black just looks gray. But you said you put a strike through, things that you want removed, and then.
Yeah. So, I mean, I can just tell you, it's only a couple of things.
All right.
And then I did a footnote and citations and arguments. So I don't intend to make any additional argument. I put the arguments in the footnotes as to why we were requesting that. But in the second paragraph, starting with the attorneys will now have an opportunity. If you go about 2/3 of the way down, where it says are proven by the greater weight of the evidence, that has a red strike through, and then in green, which is what we would want said instead, have been established, and then footnote 1 explains
Okay,
why.
hold on just 1 second, please.
Okay, sorry.
That's all right. State, are you in agreement with any of this in 7.10?
No, Your Honor, and the state filed a response yesterday, a detailed response citing case law in opposition.
Okay, let me grab that too. My assistant is out. She's also awaiting a COVID test, so I don't have any of this pre-printed. I'm printing it now.
Just while you're doing that, if you want, I think our printer's colored. I can print you. It's only like 3 pages.
Still mine.
Okay. No?
I have a clean copy of the state's response if it will assist the court.
I have that. I was able to. Is yours in color also?
No,
Okay.
it's black and white.
So then I can print that myself.
All right. May I approach that?
Sure. Oh yeah, this is a lot easier to follow. Okay, so I can throw the first one away. No, the first one's thicker.
She's already printed on both sides.
No, I didn't. Oh, there's an attached email, okay. Okay, so green is as language you want added. Red is, with a line through it, is the standard language which you think should be taken out. And that's it.
Yes, ma'am.
But you left in all of the standard language one way or another, other than the fact that in the defense motion, it's either in red with a red line through it if you want it out, and green means you've added it.
Correct. That's
Okay.
how I meant to do it. It's not exactly,
Okay.
it's just a mistake, but
Okay.
that's how I meant to do it, yes.
And the footnotes are the reasons why.
Yes, ma'am.
Okay, do you want to add anything to your written motion?
No, ma'am, just that, the minor, minor, relative term. The changes that we asked for, and there aren't that many, are just, mostly surrounding the burden of proof. One is to remind the jurors of the state's burden to prove aggravating factors beyond a reasonable doubt where it's not there. And then the other is, we take issue with the burden of proof on mitigation. The instruction itself in another part says a mitigating circumstance is not limited to the facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. So we take issue one with the instruction, which in the next paragraph says it has to be proven by the defendant, or an implication that it does, because it can be anything, it can come from anywhere, and also with the burden of proof. But, all of that's in the footnotes.
Right, and then the states drafted a response, SF 205, basically advocating for the standard instructions, indicating that the court has read the standard instruction numerous times, citing each time that the court has read that, the standard instructions to the jury.
Yes, Your Honor, if I could just elucidate on that, and that is that 17 times this court instructed the Venari that the defense's burden regarding mitigation was the greater weight of the evidence. And although the court did not read the full 7.10 to the jury, it did acquaint the Venari with the terminology and the definitions that it would further and completely instruct them later on, and that was the court's intent. So 17 times the panel heard that instruction. Significantly, the defense wants to not just take those words out, but wants to totally eliminate any verbiage about the defendant's burden of proof regarding the establishment of mitigation. They also want to modify what the state's burden is with regard to establishing an aggravating factor, and that has been soundly and roundly rejected by the Florida Supreme Court by the Bright case and its progeny, and that's cited in our response, and I quote from it. It is not, the state does not have to prove beyond a reasonable doubt. They're not like little elements, so to speak, and the case law establishes that, Your Honor. So I would direct this court's attention to the state's response. I'd also point out that what the defense has done with the red strike-throughs are not complete. They substitute the word, decision for the word conclusion on the last page of their modification. And they also shuffle the paragraphs to put the paragraph that should come right after where it says mitigating circumstances, they take that out where it starts, should you find sufficient aggravating factors do exist to justify the imposition of the death penalty. They take that out and they stick it right at the bottom. You know, that's not accidental, Your Honor. These jury instructions came out post-Hearst in 2018. They were adopted and approved by the Florida Supreme Court in 2018. The case where it was done is cited in the state's response. And those instructions are before this court with the presumption of correctness. And given the fact that this court has instructed the jury and acquainted them with the terminology 17 times regarding the burden of proof that adheres to mitigating circumstances, and has correctly advised them as to the process, the state strongly objects to any modification, and that's an interesting word, any modification or altering of 7.10, Your Honor. We'd ask that the motion be denied.
Okay, I want a chance to read through the proposed instructions that the defense has submitted and read them side by side with the standard instruction, just so that I can see what's been moved around, and I will have an order for you by tomorrow. Okay, what's next?
Judge, can you clarify, is July 19th, we had talked about it, but I don't know that we got an answer if we were in court for trial on July.
We did, and all the jurors have been notified to be present on the 19th. And then the 21st, we were going to have a short day and handle the issue with Mr. Zachary Cruz and his lawyer, I think. That's what I have written down.
I'll have to defer to you. I know that I made contact with her and confirmed one of the dates. I just don't have that information from me.
I recall that you gave her two choices.
Yes.
She took the one August.
The 7:30 in the morning date that I said no one would take.
Yeah,
What's that?
I recall seeing that in your email to her.
You just don't know what it is. The August one?
20-something, 21st.
That's okay.
maybe.
I'll look.
All right, so then the schedule for, so the schedule for next week would be the 18th, the 19th, the 20th, the 21st would be AM only, and then the 22nd.
20 seconds all day, Your Honor?
Yes.
Judge, you have on the July 14th, Thursday, you have morning court. But we just I want to let you know that that's when we're doing the motion to perpetuate testimony, so we don't have.
That's tomorrow.
What, Thursday?
Thursday, sorry, no, Thursday I had off.
Okay.
Like, in other words, not in court.
Right. That's fine.
And tomorrow I have your expert, I don't recall the person's name, but one of your two experts is going to be testifying.
Yes.
What time are we starting tomorrow?
9 o'clock?
Thank you.
Sure.
Judge, may we go on sidebar, please?
Yes. Okay, what else for today?
Judge, I have report two orders, proposed orders, one for, DMIL 3 as it pertains to item Q, which was the firing pin, which we discussed last week. I also showed the state, they don't have an objection to that order as long as the court is okay with it.
Okay,
And then also DMIL 13, which was regarding the opinion testimony of law enforcement officers. And I just took the language straight from Your Honor, from the transcript.
I think I did a written order on this.
We have to do one on the expert designation for the cops, the crime scene people. We talked about it, but I don't think there's an order for that.
Do you want to do it that way? You're used to telling people what to do, right?
No, it was your motion. You don't know what
It
was
was
said?
it was similar to the law enforcement. But they know the law. I don't remember.
I don't know if it came to a,
It was the same, it's similar to law enforcement opinion testimony.
as well as sort of walk through.
We'll look at the transcript. Sorry. That's okay.
Can you make copies of these, please?
I can make.
So I had already written an order on one of the issues. I just haven't printed it yet, and then, so that's one of your orders and two of mine.
Okay.
If you can,
And we just need a copy for us and a copy for the
correct, thank you. You have a copier, oh, you have a copier? There's a copy machine back.
You do have one back there, it would be fine.
In the,
Charlene, would you
in
mind?
the far corner, there's a room that has copy machine.
Okay.
Judge, the defense just has one last issue.
Okay,
We have an agreed stipulation because the Daubert hearing is going to be taking place after opening statements. This defense will not make reference to the neuroimaging in their opening. So I have an agreed order or agreed stipulation between all the parties.
okay,
This is for the court file.
okay. Does it need my signature or no?
No.
Okay.
Yes, she's the one who drew it up.
And did Your Honor have an opportunity to speak with the Chief Judge about the camera here? From Monday?
No, but I did speak to the media, and they were kind enough to give me a viewing of the different angles. Thank you for bringing this up, because I had forgotten about it. So, the reason that the camera has to be there is because if it's over here, first of all, it can't be here because it can't be in my way. We don't want to get the back of the court reporter's head, and putting it over here, the view is to get the view of all of you, okay? I understand your consideration, your concern with the camera, but when I went back where the gentleman, would you raise your hand, cameraman, where he's standing, they have monitors where you can view the different camera angles. The view that gives is identical to the view that he can get from his standing camera, and they showed it to me. In other words, he can zoom in and literally see a pore on somebody's face. They showed me, which is this. Which one did you say was stronger?
This one goes 4 times, and they're equal in like distance.
They did suggest that I can write an order that they're not to film any type of documents. So if you're writing notes, that can't. In other words, there's no. I think you all told me you can't see the written notes that are on their desk.
Not from that angle.
And so I could enter an order saying that they cannot zoom in or attempt to see anything that's on your desk. But as far as the view of you all, it's the same as what that camera can do.
So if it's the same as what that camera can do, then why does that one have to be there?
I don't know.
That camera is for the witness and the judge. That camera there.
The big one.
Yeah, that one is just for the attorneys.
But
And this one is for the podium.
But in other words, they can, in that camera, and they sometimes do, zoom in on you all when you're talking. It's no different than what this camera can do. Do you see what I'm saying? They can zoom in on that camera, and there's nothing I can do about it at any time, at the state or at the defense. Zoom in on the state or on the defense. So when they showed me the vantage points, I don't see a difference. I know it looks like it's closer.
So can we look at the vantage points first?
I think so. Would you be willing to show the lawyers so they can see what I saw? What they did was they showed me, they zoomed in with that camera. We had a gentleman sit here from Court DB, like right where you are, and then they showed me what they could do with that camera as far as zooming in, and then what they could do with this, and it was the same view. So even if I were them to eliminate that camera, they can still get the same viewpoint as they could with the big camera, if they wanted to, is my point. So why don't you have a look, and maybe if you see what I see, you'll understand that it's just...
Does that pick up sound, that camera?
No. What isn't plugged in?
So I'm going to do that now.
We'll take a recess and you all can go have a look, okay?
Okay, thank you.
Sure.
Is that recess now?
What's that?
Is it now the recess?
Yes.
Okay.
I'm gonna sit here though,
No, that's
because
fine.
I'm just doing some busy work.
But I will give it back to you. So she can put it in there.
Thank you.
These are all, there's agreed upon.
Yeah, there's agreed upon, they're already in motion.
Someone's gonna have to sit in that chair.
No, she just addresses it like in a catch-all kind of thing, like stipulated redactions are listed in paragraph 3A through F. She doesn't list them, but if you look at the motion, paragraph 3 has it. I mean, I don't have to tell you the laws for the video, transcripts, whatever.
Not that I know. I know him, Dad. I know him.
Some sort of final version that's been shown to the jury. Word it in a way where they understand that it's been done. copy the instructions ahead of time.
Yeah, we
Then that's what it is. So I'm sure. Yeah, right?
Defense is present. I gave you all the opportunity to view the camera angles. The camera that's on the bench in front of me, to my left, and the big, I guess we call it the big camera in the back.
So, Your Honor, here's my position.
Okay?
The defense is objecting to the placement of that camera up there. That camera can capture all of the angles, and I understand that they want to be able to move in closer to the litigants, but that's for the benefit of the public. And I think that it creates an obstruction for the defense, because then we have to be picking up pieces of paper and covering our face when we're talking to co-counsel, also conversations with our client. If the court is not in agreement to move the camera, then we would ask that, and I can fashion an order.
Was it? Wasn't.
It's on a robot. It's a robot, so they moved it to show us.
Oh, so I was going to say, even it was directed like that before. Okay.
If the court would fashion an order that the media is not to videotape any conversations between any member of the defense team and Mr. Cruz, or any conversation between Mr. Cruz and the defense team. And additionally, we would ask that there be no video of the conversations between the attorneys on this team.
I just don't know how I would do that. In other words, you guys are pretty much talking the whole time, so what would I tell them to do? Never to videotape you?
Well, if we're engaged in conversation amongst ourselves,
Right.
Or if we're engaged in conversation with our client, which is attorney-client privilege,
Sure.
then we would ask that they don't videotape. Because we believe that, it shouldn't interfere with the administration of justice or the procedure before the court. And I'm telling you that it might, because we're going to be constantly trying to pick up something to cover our face. And I can tell you that the media has read Mr. Cruz's lips and our mitigation witnesses' lips, and then televised a personal medical condition of a member of this team. So we're already aware that that has happened, and we just want to be mindful that we're able to focus on what we're doing as attorneys and not all these cameras in the courtroom.
I understand. I just don't know that I have the authority to tell them not to video. I mean, it's an open court, and whether I agree with it or not, I don't know that I have the ability to tell them not to take photographs of certain parts of the courtroom.
I think that the administrative order gives the chief judge and the trial judge discretion as to the amount of cameras, the placement of the cameras, and what can be videotaped. Ms. McCann, do you have?
I do, Your Honor, and I do believe that, it's an open courtroom, and the media would have a right to be heard on this if talking about curtailing their right to what they can take photographs of. I mean, nobody wants to have their notes photographed. The state doesn't want to have anything on our table, and we're certainly in a more vulnerable position from a camera coming from behind. But they may want to be heard on this issue as well.
Did you see what I was talking about, though, that large camera, if he wants to, he can zoom in as close as this can.
Yes, and that kind of exacerbated my concerns. I didn't realize, like when you said 4 on your face, you were right.
I don't think that they would do that to anyone but maybe me, but you saw what I'm saying. So you're suggesting that I order the how can I refer to that large camera? No, that big camera, the main camera. Are you suggesting that I would order the main camera, not to video the defense table also? Or are you just talking about this one?
Well, I'm in objection to this
camera,
the one that's right in front of me and in front of you. I believe that the main camera, covers everything that camera covers, and it's unnecessary. That's one, and then I would ask for a court order to prohibit the media from videotaping our conversations between counsel and our client, and then conversations between each other. Each other meaning the defense team.
Okay, so Ms. McElroy's not here. I have to give her the opportunity to be heard, but the media, the cameramen were nice enough to suggest some alternatives or to pose some language, prohibited language that could be used by the court. In other words, they can, okay, I don't know a lot about technology, obviously, but there's a certain zoom that I can tell them, don't zoom in past this point. In other words, they're able to say, this is, I forget what they called it, frame or, what is it?
Yeah, it's a preset.
Preset frame that I can say, don't go past this point. So that's a consideration, and then they're also able to limit videoing the documents that are on the table, so that you don't have to worry about your notes being videoed.
In reference to that, Judge, and I'll have to ask Mr. Cameraman to clarify if I'm wrong, although there could be a preset in the courtroom, once the footage is sent to the individuals wherever they are, they can manipulate the photo and they can zoom in even further. So he could have a preset in the courtroom, but when he sends the feed, is that correct?
Yes.
But that's, go ahead. That's correct on any level, though.
You can zoom in on a photo.
I'm sorry?
I can be wide, very wide, and anyone, anywhere can zoom in on a photo or a video at any point.
So, Judge, why don't we do this? Why don't we notify Mrs. McElroy, and then I can look at the administrative order again, because I believe the court has some discretion, but I need to review it again. And I think it's like a balancing test like anything else, right?
Sure.
Courts, or the media's access versus his due process rights.
Okay, how long do you think your witness is going to take tomorrow, Mr. Secor? The whole day, or?
To be
I'm
honest
just-
with you, I'm not sure. I would be surprised if it were all day, though. She's only addressing one issue, so I would hope that it wouldn't be much more than a half a day, but
Okay,
I can't be sure.
so if we start at 9 tomorrow, if I set this issue, we could, I don't know if it's easier to set Ms. McElroy for like 11:30 and just take a break from the motion, or to do it at the end of the day.
I may have her number.
I'm sure she'll make herself available whenever we ask her to, but I just don't know if you all want to do that, if you want to take a break from the hearing and do it in the middle of the day, or if you want to do it at the end of the day, but I don't know when that's going to be.
I think whatever Your Honor would prefer, I think it's probably perfectly fine to do it in the middle of the day. That way, Ms. McElroy doesn't have to wait around.
All right, so why don't we do, can someone from the media notify Ms. McElroy for me, please? Okay, if you can let her know that I will hear her argument as far as, Ms. McNeil, will you be more specific as to what you're asking me again, please?
Removal of the camera on the bench, and then a request that the court enter an order limiting the media's coverage of defense counsel and defendant's communication, and communication between co-counsel. Does that make sense?
Yes. Okay, are there any outstanding matters to be heard this afternoon?
Nothing from the defense, Your Honor.
Okay.
Not from the state.
Did
you say the time for the,
If 11:30 works, I think that's probably the best course. You mean for the Miss McElroy or for everybody? If Miss McElroy can be here at 11:30, we'll take a break because we don't know how long the motion's gonna take. So we'll take a break at 11:30 to hear from her and from the media. Okay, thank you. Other than that, we're in recess until tomorrow and we'll start at 9 a.m. All right, thank you.